Everyone, it is my pleasure and honor to introduce the OISTE Foundation webinar on the human rights to privacy in the age of surveillance capitalism. So as the audience that is following WISE-Key and OISTE webinars, this is one of the webinars that we do in cooperation with the High Commissioner for Human Rights. This is the third time OISTE has prepared that webinar. At the beginning was physical meetings at the Palais des Nations in Geneva. Now, due to the COVID situation, obviously we are forced to go online, but we have the honor and pleasure to have a very prestigious panel covering different aspects of the problem, both political aspects related to regulation, aspects related to the use of technology or the abuse of technologies, and also policy analysts. And they are going to, during a 1.5 hour, work together with us, with me as a moderator, to trying to answer all potential questions and concerns that we will have. As it is a webinar, you have the possibility of submitting questions to us. I will be addressing those questions to each participant as we move forward. And you also have the possibility to address the questions directly through the Q&A Zoom facility. So participants, if you would like, while the others are speaking, to answer that question, you can also obviously do directly through that facility. So the webinar is going to be on 2 languages. We're going to be starting in French, as we have the honor and privilege to have with us Pierre Maudet, Conseiller d'État of Geneva. And I will be switching to French to start the interview with him, and then we will go back to the panel with the experts to debate the subjects that we will initiate with Mr. Maudet. So, bonjour, Monsieur Maudet, c'est un plaisir de vous avoir. Encore une fois, on se voit toujours dans des manifestations physiques. Maintenant, c'est le moment du virtuel. Nous, on va parler de la confiance numérique. Hein. La confiance numérique, ça est devenu un grand problème, car l'accélération de la technologie est exponentielle aujourd'hui. Ça veut dire que ça dépasse complètement la façon comme les gouvernements peuvent développer des lois, ou même les organismes internationaux peuvent développer des systèmes de protection pour les citoyens du monde. L'accélération du Covid, le fait que le Covid il est là et qui représente une priorité sanitaire, ça fait aussi qu'on est en train d'utiliser des données publiques de façon des fois abusive. Et on a toujours regardé Genève comme ce pôle d'excellence. Genève, par mètre carré, peut-être c'est la ville au monde qui a plus de savoir-faire dans le domaine, car on a les organismes internationaux, on a les WEF, on a les CERN, on a tous ces multi-stakeholders qui travaillent tous les jours pour mettre en place des standards et des solutions pour protéger l'individu. Quelle est votre vision pour Genève? Qu'est-ce qu'on fait déjà à Genève et comment est-ce que vous voyez la suite? Quoi est-ce que Genève pourrait devenir? Je sais que vous travaillez sur la blockchain, que vous étiez à l'origine du Trust Valley, l'initiative avec les cantons de Vaud. Quelles sont les conséquences aussi pratiques de toute cette activité-là? What is the bottom line? Quel est le bénéfice que Genève, ses citoyens et ses institutions pourront tirer de cet énorme travail qui a été fait jusqu'à maintenant?
Merci Carlos, merci d'abord de l'invitation et de la possibilité d'adresser quelques mots d'introduction. Pour répondre directement à la question, je confirme que Genève a sans doute un rôle particulier à jouer, mais peut-être en amont, Genève, comme d'autres villes occidentales ou d'autres villes de la planète, s'est rendu compte avec la pandémie que la notion de confiance, elle était clé dans le domaine numérique, ou pour le dire autrement, qu'on était ultra dépendant du numérique, que ce soit pour des questions de continuation de la scolarisation des enfants, d'infrastructures, de santé hospitalière, etc. Je crois que vraiment depuis 1 an, on a pu constater à quel point on était dépendant. Et qui dit dépendance, dit besoin de confiance, pose la question du rôle de l'État. On y reviendra peut-être tout à l'heure, mais il y a, comme le veut la tradition, des votations régulièrement en Suisse. Il y en a une ce week-end qui porte sur le e-ID, et ça va être quelque chose de très intéressant sous l'angle de la confiance. Donc, je crois que Genève n'est pas différente des autres villes et des autres pays. Beaucoup de questions se posent aujourd'hui au niveau de la confiance numérique et de la capacité de maîtriser le système numérique. qu'est-ce que Genève peut faire de plus? Et là, je réponds à votre question, Carlos. Genève, alors, concentre un grand nombre de talents et de compétences, vous l'avez dit, au niveau technique, voire technologique. Vous avez mentionné la présence du CERN, c'est évidemment pas le seul, mais c'est un environnement important. Donc, sur la capacité, par exemple, avec notre université, de développer des solutions pratiques grâce à la physique quantique sur l'amélioration des nœuds de sécurité numérique, on a évidemment une carte à jouer. Mais il faut aller un pas plus loin. Et ce qu'on essaie de développer maintenant depuis quelques années, c'est de travailler sur le plan éthique, de travailler sur le plan du droit, sur le plan des normes. Comme vous le savez, nous accueillons, et ce n'est pas Mme Pilet qui va me démentir, elle a été longtemps à Genève avec le Haut Commissariat, de nombreuses organisations internationales qui, avec le retour d'une administration plus multilatérale aux États-Unis, va renforcer l'importance de notre place pour élaborer les normes du XXIe siècle dans le domaine des télécommunications. C'est ITU, l'Union internationale des télécommunications, c'est WIPO, c'est le domaine de la propriété intellectuelle. C'est tout ce réseau qui doit maintenant travailler, il le fait, sur les codes, les normes, ce qui va permettre de mettre un peu des règles dans la boutique numérique. Ça, c'est le premier point. Et puis le deuxième point, qui est très, très important aussi et qui émerge maintenant, c'est tout le rôle du secteur privé. Alors, quand on parle du secteur privé à Genève, on parle évidemment de la finance et donc de la finance durable et donc des solutions technologiques qui peuvent venir adosser les besoins en financement pour l'atteinte des objectifs mondiaux du développement. C'est évidemment tout le domaine du trading et c'est un domaine dans lequel le secteur privé est évidemment très fort et peut amener là aussi des éléments très innovants grâce à la blockchain sur la confiance numérique. Je parle des smart contracts, de tout ce qui permet d'accélérer la vente de biens et de marchandises de par la planète. Et le troisième et dernier élément, c'est le mix entre le public et le privé. Et ça, c'est un enjeu très, très fort. C'est aujourd'hui, je pense, le point le plus central parce que c'est là qu'il y a le moins de confiance entre les partenaires, publics et privés, pour faire en sorte que les solutions numériques, elles soient reconnues, admises et que finalement la population puisse en bénéficier.
Merci beaucoup. Et vous avez mentionné la votation sur l'identité de citoyens, les EID. La Suisse va devenir, si on vote pour, un des pays pionniers sur la chose. L'Estonie l'avait fait, ça fait quelques années, ça les a aidés dans certains secteurs. Mais aujourd'hui, peut-être à cause du Covid, on a un niveau des doutes supérieurs à celui-là qu'on avait, ça fait quelques années. On commence à avoir un problème de confiance. On ne fait plus confiance à personne. On ne fait pas confiance à des sociétés. On ne fait pas confiance aux Nations Unies. On ne fait pas confiance au WEF. On ne fait pas confiance non plus à l'État. Alors, comment est-ce que vous pouvez peut-être nous dire quels sont les arguments vraiment pour cette confiance? Comment est-ce que l'État peut reprendre la confiance du citoyen? Et est-ce que le modèle qui est présenté, cette participation État, secteur privé, c'est le bon? Est-ce que la question a été bien posée par rapport à l'élection? Est-ce que vraiment on aurait dû peut-être séparer d'abord, est-ce qu'on veut faire une votation, une identité électronique et plus tard voir si est-ce que le secteur privé pourrait avoir un rôle? Quelle est votre vision sur la chose? Je pense que c'est quelque chose qu'aujourd'hui les gens sont en train de prendre son choix des votes et c'est important de clarifier ces points-là.
C'est une question très intéressante et le débat qu'il y a aujourd'hui en Suisse, à Genève, mais dans les autres cantons aussi, il est intéressant. Si je devais faire un pronostic, je pense que ça va être non dans les urnes. Je pense que ça va échouer. Alors, en Suisse, on dit que le peuple, il n'a pas toujours raison, mais il a toujours le dernier mot. Et ce dernier mot, il sera provisoire parce qu'évidemment que la question de l'identité électronique, elle va continuer de se poser, que ce soit oui ou que ce soit non. Et honnêtement, je pense que ce sera plutôt non parce que les gens n'ont pas encore assez confiance. Le débat, il va se poursuivre. Mais il porte sur quoi? Vous me demandez en fait où sont les pierres d'achoppement. Alors, une des pierres d'achoppement, un des problèmes qui apparaît dans cette votation, c'est exactement ce que je disais tout à l'heure, c'est l'articulation entre le secteur public et le secteur privé. C'est en fait qui maîtrise les données, par où est-ce qu'elles transitent, comment je peux avoir confiance sur ce que l'État va accepter de déléguer au secteur privé ou pas. Ça, c'est peut-être le point le plus fort et le point sur lequel les réponses aujourd'hui qui sont amenées par les promoteurs du projet sont le moins crédibles. Et comme vous le savez, la confiance, ça ne se décrète pas. Ça se construit patiemment, ça se fait avec des exemples. On a eu il y a quelques années une situation, et vous le saviez bien, Wisky était impliqué dedans, de pionnier dans le vote électronique. Mais aujourd'hui, on a un phénomène plutôt de recul. On voit bien que ça peut être intéressant de voter électroniquement, surtout en situation de pandémie, de ne pas devoir se déplacer. Mais en même temps, on a le sentiment qu'on n'a pas toutes les garanties de système pour être certain que les votes ne sont pas manipulés. Et puis, il y a eu quelques exemples récents au niveau de l'actualité internationale qui ont montré que la formation de l'opinion et parfois les aspects techniques du vote pouvaient être pilotés à distance. Donc, pour moi, l'enjeu, et je réponds en ça à votre deuxième question, dans cette votation, c'est passé, c'est dans quelques jours, mais de manière plus générale, c'est d'arriver pour les pouvoirs publics à expliquer beaucoup mieux où est le gain pour la population, qui ne doit pas être un gain de productivité, mais qui doit être un gain éthique, un gain de traçabilité, un gain de compréhension. On ne doit pas courir après le progrès pour le progrès. Ce n'est pas ça qui va faire avancer réellement la cause numérique. Et je pense que quand on parle d'identité, aujourd'hui l'identité elle est centrale, ça génère des guerres un peu partout sur la planète. On ne doit pas ériger une appartenance contre les autres. On doit montrer que cette identité, elle est multiple, qu'elle peut être reconnue comme telle et qu'on arrive à avoir de la confiance parce que précisément le système qui est complexe, on arrive à le décortiquer et le comprendre. Et moi, je fonde beaucoup d'espoir sur la blockchain. Je pense que c'est la technologie sur laquelle, avec beaucoup de pédagogie, on va réussir à convaincre la population que c'est vérifiable, inviolable et que ça nous permet véritablement de maîtriser notre propre identité numérique. Je pense que c'est l'enjeu principal. Et donc, je pense que ce week-end, s'il y a la votation en Suisse, ça aboutit à un non, ça doit être perçu comme l'occasion de recommencer le travail from scratch, de redémarrer pour un vrai effort de communication et de conviction, avec la question centrale du rôle de l'État. Le rôle de l'État dans la maîtrise des données, dans la vérification de la qualité de celles-ci et la capacité pour chaque citoyen de dominer ses propres données.
Merci, Monsieur Maudet. Merci pour votre leadership. Je sais que vous êtes aussi en train d'organiser une réélection. Je vous souhaite les meilleurs. Vous restez avec nous parce qu'on va revenir à ce sujet sur des points différents qui vont être entamés par les experts. So I am switching now to English again. And just to summarize the position, we discussed about the position of Geneva, why Geneva with so many multi-stakeholders working on the digital transformation the world requires. It is a unique position to inspire many other cities in the world, and why even you guys like Microsoft and others are putting so much focus in Geneva. So we discussed that point, and also the elections that they are happening in few days where Swiss our citizens are going to decide yes or not they will be using a digital identity, electronic identity to do all kind of transactions in the country. Obviously, that opens the big subject here, which is trust, which is do we trust institutions? Do we trust the government? Do we trust the international organizations? Do we trust the technology companies? And on that, I would like to give the floor now to Navi. Thank you very much for joining us. You have been running the entire High Commissioner on Human Rights in Geneva for many years. Your experience on those subjects are essential, as you have witnessed a progression of the definition of human rights. I think human rights definitions are progressing as we are adding new things human people do, and one of them is digital life, or digital life is as important as our analog life. And as a consequence, what is your views, Navi, on where are we now and where are we going, and why human rights and the Commission in particular is becoming so strategic and important?
Thank you, Carlos. It's a great privilege to join this panel. And of course, we all acknowledge that we have a good system, a good international framework based on international human rights law. And we have guiding principles on business and human rights. And so it would be very rewarding if we, the panel, focus on the gaps in implementation and the gaps in protection in this framework. So as I said, we had this framework, so it's surprising to me that it was only in 2013 that the right to privacy came to be considered before the UN General Assembly and the Human Rights Council, and that, as you know, happened after Chancellor Angela Merkel and President Dilma Rousseff complained that their personal mobile phones had been hacked. So digital communications technologies crucially benefit the protection of human rights, but they also come with challenges that undermine human rights, such as the invasion of privacy. So on the one hand, digital technologies facilitate global debate, they foster democratic participation, but on the other hand, they've enhanced the capacity of governments, enterprises, and individuals to conduct surveillance, interception, and data collection and sharing. And so the risk now is that state and non-state groups are developing sophisticated digital surveillance capability outside regulated controls. The GA resolution affirms that all the protections of human rights that we have offline should be introduced online. And so they asked all states to review their procedures, practices, and legislation relating to communication, surveillance, interception, and so on. And they called upon all states to ensure full and effective implementation of their obligations under international human rights law. So I mentioned international human rights law. The key provisions then are Article 12 of the Universal Declaration of Human Rights, which provides, let me quote, "No one shall be subjected to arbitrary interference with his privacy, family, homes, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attack." And then you have Article 17 of the International Covenant on Civil and Political Rights that uses the same language. So it's very interesting that the OIST Foundation has raised some important questions with regard to the adequacy of protection afforded by Article 12. And important questions have been raised on how the protections are differently experienced, say on gender or LGBT, to which I would add poor and developing countries compared to rich countries. So it's a very interesting exercise to review the provisions that were put in place long before the digital era. The rapporteur, for instance, has invited public submissions on other aspects of human rights, because the digital collection of personal data affects other human rights, such as health data privacy, the use by corporations of personal data, and the effects of privacy breaches upon marginalized groups. Now, the human rights mechanisms have provided extensive guidance on what is privacy, what comprises interference and arbitrariness. Challenges arise over how to protect confidentiality and personal identities in the new and emerging market of big data collection. Metadata may give an insight into an individual's behavior, social relationships, private preferences, and identity that go beyond even that conveyed by accessing the content of private communication. So this risk needs to be countered by reform of existing policies and practices to ensure stronger protection of privacy. So the bottom line is that states must refrain from employing unlawful or arbitrary surveillance techniques. And there are a number of criteria as to what constitutes arbitrary and what is unlawful. For instance, you may have a national security law on protection, but if it's not in accordance with the international law and the aim of international law, then actually your national law will not be in compliance of international law and will be illegal. So applying all these checks and balances of international human rights laws, which I've just mentioned, lawful, proportionate, necessary, legitimate aim, respectful of other human rights, and so on, let me say that bulk surveillance programs fall short and they are deemed arbitrary, even if they serve a legitimate aim, and even if they were adopted on the basis of an accessible legal regime. So mandatory third-party data retention, this is where states compel internet service providers to store metadata about their clients' communications for subsequent law enforcement and intelligence agency access is also deemed to fall short of these standards of necessity and proportion. Many national frameworks also lack user limitations, thereby allowing data collected for one purpose to be used for others, or allowing the sharing of data from different agencies. So such data sharing regimes have been struck down by many courts in many states. Unlimited sharing will not be in compliance with Article 17 of ICCPR. So in practice, many states have revealed a lack of adequate national legislation. The Special Rapporteur on the Right to Privacy reports that more than 1/3 of UN member states have no privacy laws at all, while most of the other 125 states have laws which cover some of the contexts where privacy may be threatened, but not all. Some important threats to privacy, especially those arising in the context of national security, intelligence, and surveillance, are inadequately regulated in most countries of the world. Now, with regard to business enterprises, we have the guiding principles on business and human rights, which was endorsed by the Human Rights Council in 2011, but however, it's not a binding agreement. And, it's just wishful thinking that business will comply with this, which means have a policy, have a commitment on protection of human rights. I'm happy to say, I was there during this right to privacy discussion for the first time, as well as the guiding principles on business and human rights. So I'm well aware of the multi-stakeholder efforts to come up with due diligence standards and so on, oversight, exercise transparency, and so on. However, gaps in implementation of the guiding principles continue to be alarming, especially in relation to the sale and purchase of personal information of individuals. Massive increases in technological resources and inexpensive, potentially limitless cloud storage enable the storage by organizations of massive amounts of data on private individuals. And in many cases, use of this data is a source of revenue for them. To address this concern, the EU introduced the General Data Protection Regulation, GDPR, with global territorial scope. It provides data privacy of EU citizens and residents, no matter where in the world the company using that data is located. To ensure that organizations comply with the strict set of privacy rules, the GDPR imposes heavy penalties as high as 4% of a company's yearly revenue. But the good news is 60% of technology companies have put in place GDPR policy, and 20% are in compliance. And of course, huge fines have been levied so far, which show the reach and impact of GDPR. $5 billion fine against Facebook's Cambridge Analytica, the political research group that accessed the data of more than 87 million Facebook users, and others who were penalized with heavy fines included British Airways, Haga Hospital, Netherlands, Google, Vodafone, and so on. GDPR extends jurisdiction over companies located anywhere in the world, which is a welcome provision. Companies anywhere in the world who process the data of EU citizens and residents. And GDPR requires the consent of the individuals prior to the use of information relating to them. GDPR places limits on the amount and purpose for collection of personal data and the transfer of personal data from inside the EU to outside. And it introduces new data privacy rights, such as the right to know what personal data is collected, how it is stored, the legal basis for the collection, and who the data is shared with. And it has the right to be forgotten, whereby companies must delete all personal data upon request. It has built-in oversight mechanisms and data protection officers. So really a most comprehensive and advanced protection law on the right to privacy on digital information, and one hopes that it will be emulated by states. I think my time is just going up. I want to mention that other countries have passed similar legislation, the California Consumer Privacy Act in the US, LGPD in Brazil, and in my own country, South Africa, Protection of Personal Information Act. Now, our South African law more or less follows the GDPR, but there are differences in that it allows cross-border transfer of personal information to a third party that is subject to legal or corporate data protection rules substantially similar to South Africa. So I do agree with the special rapporteur that you can't do this by national legislation alone without regard to the international context. The SR on the right to privacy concludes that an international framework with consistent data protection and clear rules for transnational access would help weigh privacy protections and the competing interests that nations may have in gaining access to data, for example, in the context of law enforcement, or that multinational corporations may have in managing data flows internally. Effective protection of the right to privacy in the context of modern communication technology will require our ongoing concerted multi-stakeholder engagement. So I look forward to the expertise that will come from my fellow panelists. Thank you, Carla.
Thank you very much, Navi, for very comprehensive analysis. I want to change maybe a bit the distribution of which originally I had, because I think you mentioned one very important point, which is 1/3 of the countries do not have a privacy protection, neither laws and maybe not even the means to do so. Steve, from your view, I'm going to jump on you, Steve, because I think this is a very important point from Microsoft. We had discussions whether this should be done by the individual, the country, or a corporation. Maybe you can develop this further. What are the advantages on each? I obviously see huge advantages to have a major corporation taking care of that, but will that be conflict of interest potentially there? So your views will be highly appreciated.
Yeah, well, thank you. Let me start by thanking Navi for that overview of the international human rights regime and how it applies and should apply to this global challenge. It's why we need international human rights and international norms as opposed to purely private company level or even nation state level. Navi mentioned the Universal Declaration, Article 12, the International Covenant on Civil and Political Rights, Article 17. One of the challenges that people point to is that this prohibits arbitrary or unlawful interference. And those are the kinds of words that lawyers can drive freight trains through. On the other hand, we do have increasingly accepted international norms that have been developed in a multilateral fashion and multi-stakeholder fashion, bringing in human rights defenders and civil society to have some sense as to what we mean by that in the AI era, the digital world we now inhabit, rather than the old analog rules that worked in the physical world. One way I like to think about this, I'm a human rights practitioner, I head up our human rights team at Microsoft, is to think about how we've seen this evolve and where we would like it as human rights practitioners, where we'd like to see this evolve. I even think of it as privacy 1.0 was notice and consent. The idea that if you went onto a website, you would say, click here to give your notice and consent. But there were always questions, how much real understanding and how much choice about consent did you have if it was an all or nothing. Privacy 2.0, which I view as kind of the GDPR, the data protection regulation from Europe, was more about access and control. That not only did you give notice and consent, but you should have access to what people are collecting and some control over it. What I like to point out is both of these actually require end user diligence. To protect your human rights, you need to become an expert in digital technologies and able to read the fine print of the provisions being provided. So one of the things I've been talking about in the global human rights community is the idea of a privacy 3.0, which would be, let's govern companies' personal data collection and uses in the first place. Make some forms of data collection, some types of uses, unlawful. Unlawful in the sense that under the International Covenant, where you're not allowed to conduct do things that violate and constitute arbitrary and unlawful interference with privacy. Let's define what is an unlawful and what is effectively an arbitrary interference with a legitimate, very fundamental right in the human rights regime, which is your right to privacy. There's no real hierarchy in human rights. Freedom of expression matters, privacy matters. Of course, you can go all the way through the International Covenants on Civil and Political or Economic, Social, Cultural rights. All of them are interrelated, all of them depend, but there is no question that things like privacy are at the very core of human dignity and the right to form our own opinions, exercise our own agency, make decisions that aren't informed by what others are going to, how others might use that for their benefit or against us. I'll stop there so we have others who participate. I will say, if you're interested in how we've approached it as Microsoft, we have out on the web, we believe in transparency and in-user control. We have a privacy dashboard for any of the Microsoft products or services. So we have a Microsoft privacy statement, and then lots of detail with links as to how you go into the Microsoft properties to set the preferences you want. Do you want advertising to reflect what we know about the data you've permitted us to use? You allow that. If you'd prefer not to, you click the no, and you'll get less targeted advertising, perhaps less relevant, less interesting, but it won't be based upon use of your data. And in all instances, we're very clear. We do not believe it's appropriate. So we're in our public statements, we're very clear. We promise we're not going to use what we call content-based advertising and targeting. That is, we won't use anything in your email or your chat, any of your files you stored through Windows, your voicemail, your pictures. Any of that personal data will not inform the way we might target advertising to you if you'd prefer more personalized advertising. But we do think that we ought to be providing choice, and there ought to be some things we just do not do by default. So I'll stop there to let others speak and then look forward to coming back in.
Thank you very much, Steve. And we will get back to you later also, because obviously that will have consequences in the way those very large corporations will work. So maybe following this private sector approach to privacy, just to talk about with Alana, I mean, you run a very large company, which is PMI, and privacy issues, and the beginning of what we call a B2C journey. You know, PMI is becoming a consumer-oriented company now with the new products like IQOS and other. So what that means for privacy within the organization. Also, how is privacy organized inside within PMI to protect the human rights to privacy? I mean, privacy is one thing, human rights another. I mean, you're in a very kind of sensitive sector, which obviously needs some clarifications, and I think your views will be very enlightening. Alana, the floor is yours.
Thank you, Carlos. That's very kind, and that's a great setup for what I thought I could add here, because when I was originally asked to join this event, I did struggle over what I could contribute to this impressive panel. And really the only answer came when I drew upon why I joined Philip Morris. And prior to PMI, I actually served on 2 technology companies. I was responsible for the legal department of an ad tech startup. And then I was responsible for all things tech amongst a bunch of other things at a company which now predominantly makes income from data scraping. Both of those industries are ones where the law in many ways has yet to catch up. And the struggles to update the e-privacy directive into a regulation are indicative. And historically, they also haven't been the most compliant. This makes them cutting edge and exciting, but I have wanted more. And this ties into why the premise that you started with, Carlos, so I thank you for that again. In a world which has rapidly developing fourth industrial revolution technologies, I really wanted to join a company that thoughtfully considered the implications of its actions. Ethical decision-making is now part of PMI's fabric because it has to be. PMI doesn't shy away from its history, and it understands the baggage and responsibility that comes from being big tobacco. And believe me, there's a lot of baggage, which is why, as Carlos alluded to, PMI is undergoing a transformation giving those who would otherwise continue to smoke a better alternative. And it's not doing it because it has to, it's doing it because it believes it is the right thing to do. Just like with artificial intelligence and other new technologies, they hold great promises, but you need to pair them with ethical oversight to ensure that they don't exacerbate social inequality or lead to human rights violations. So PMI may not be a cutting edge technology or data company. We are at the beginning of a B2C journey, but it is the kind of company that's doing the type of decision making that is there to try and meet the challenges that come with the promises offered by a lot of technological advances. I'm not going to try and educate anyone here about human rights law. We've been given great overviews already, and I'm sure that we will have more. However, it is worth remembering that law is pretty much always lagging behind technology. So the Universal Declaration of Human Rights and the Covenant on Human Rights were adopted after 2 world wars, and belated decision in defining and legalizing a system of universal values. Today really is no different, and we can't rely on lagging social, political, and legal processes to sufficiently provide the safeguards to ensure that these data-intensive technologies don't impede on human dignity, autonomy, and privacy, or the exercise of human rights in general. I'm not going to try and purport in terms of how, in a world where both states and companies are able to track and analyze, predict, and even manipulate people's behavior, how do we ensure that it's used to advance human progress and contribute to the promotion and protection of human rights? But I can instead give some small examples so I can illustrate how even tiny things can make big differences. Because as a lawyer, I know that we need more legislation. Until then, we also need ethical, responsible decision-making to work together and to always keep in mind that human rights are universal. Ethical decision-making can be as much about what is not done as well as what is done, and addressing the consequences of each decision. At PMI, this isn't quite as exciting as making sure that we don't use technology such as face recognition for anything to do with supervision and control. Instead, it's more about decisions to stop selling cigarettes in the future and not invest today in selling them online, even during COVID, when there's been a significant rise in online shopping, social media use, etc. This decision has implications. As in many industries, our supply chain evolved rapidly during COVID. This has included an increase in unscrupulous actors acting online and selling illicit or counterfeit product, or selling legitimate product in ways that don't comply with existing laws. While these challenges apply to e-commerce of any kind, they cause particular concern when it comes to the sale of age-related goods like tobacco and nicotine products. For example, illicit actors are unlikely to comply with minimum age laws and may share misleading messages about alternative nicotine systems. PMI recognizes that it has a responsibility to all of the consumers of its products, including those who purchase these illicit or counterfeit goods. It also recognizes it can't address these issues alone. So in today's hyper-connected world, with growing concerns around global security, the proliferation of criminal organizations, and the surge of new digital tools, it's more important than ever for public and private bodies, law enforcement agencies, brand owners, and online platforms to come together and exchange expertise, ideas, and opinions around common goals. We cannot advance human rights to address the challenges of today and tomorrow's technology as autonomous actors. Working together also reminds us that in a world which can feel highly polarized, or that the differences between countries and cultures seem huge, human rights are universal. Human rights are born out of the strong feelings that we have when a human need is ignored or interrupted. We're here today because of this. New technology may enhance or undermine those human rights, but it won't change how we can work together to continue to strive to make balanced, proportionate, and ethical decisions. Now, in terms of our overall privacy program at PMI, Navi talked about many laws, and she talked about the GDPR. That was a gift to privacy practitioners because it gives us a starting point to create a global standard. At PMI, we do have a global privacy program with the GDPR as a baseline, and it's applied even in countries where there is little privacy legislation. As those regulatory environments in other countries have caught up to Europe, often we therefore need little to be done because we already have those established principles, standards, and best practice. What can make privacy tricky for organizations is this balancing exercise, the need to be proportionate in your decision-making. And you have to do that with many tricky privacy questions to ensure you're lawful and fair. The e-privacy directive, which is still in the process of being revised, it fills some of the gaps that the GDPR has, which again shows how difficult this area is. I'm very much with Steve. Consent doesn't often equate to fairness, especially when individuals don't appreciate the consequences of their consent or don't really have much choice as to whether or not to give that consent because they want to end up using some service or product and they can't unless they give that consent. This inability to make privacy formulaic is really what keeps people like me in a job, but it is also one of the main things that makes privacy programs in large organizations difficult. Carlos, I think you're on mute.
So thank you very much, Alana, for your comprehensive presentation. I always impressed how a large corporation like PMI with such a complex sector, you are making such a concrete steps towards the protection of consumers, right? Because this is one of the top priorities when you enter into e-commerce related activity and you expand your reach. So I would like to move now, and I'm going to get back to each of you later with some kind of interrelations between the comments that have been mentioned around this roundtable. But I would like to move now to Estelle. Estelle, you are a senior policy analyst on GDPR, and you are part of the expert group in the European Commission on GDPR. So maybe we can zoom a bit on GDPR. Steve has mentioned that GDPR is privacy 2.0. So it's a great way to define the progress in Europe on GDPR, but we also know that GDPR can be complex, cumbersome. We are a cybersecurity company. We have offices in many European cities, and we know how complex GDPR sometimes are for business. So what is the trade-off on GDPR, and how do you view the future of GDPR as a way to continue protecting privacy and citizen and eIDAS without reducing the potentiality of business?
Thank you for this question and for the invitation. Right, so I think the GDPR will continue to give us a lot of food for thought and discussion over the coming years, and it's still a relatively new legislation, even though a lot of its bases have been existing in Europe for the past 25 years, as a lot of the law builds on what was previously the Data Protection Directive in Europe. So first, something that is obvious for a lot of European, but the differences between those two rights is maybe not for others, is that the GDPR actually does not protect the right to privacy, but it protects a different fundamental right in Europe, which is the one to data protection. And we have a separate framework that Alana mentioned for privacy, which is the e-privacy directive that is currently being reformed. And so one part of the challenge is, I guess, is to first understand the interplay between those two rights and how they are complementary and how they both need to be protected, but how privacy is about protecting really what is your personal sphere, and personal data is a positive right in a sense that helps protecting privacy, help enabling other rights, also helps protecting against discrimination, et cetera, But legislation to protect data protection are not there just to create stringent requirement on companies. They're here to reinforce people's rights, and they're also here to set the basis of how data can be used in a responsible manner. So I think one of the main issue we had with when we start discussing data protection is a lot of time it's framed as a barrier to trade and something that is burdensome and complicated and really seen as a sort of a compliance bureaucratic type of domain, instead of an enabler of different type of innovation that could happen with a more data responsible economy, a more a tech perspective that would put human at the center of innovation. And a lot of companies are moving toward this direction, and a lot of making the effort for that. But the reality is that if only a small portion of companies are making the effort to comply with the GDPR, it's true that those might be find themselves in a differable competitive situation compared to company that would sort of continue a business as usual of data harvesting and no protection for users and monetizing this information and profiting from it, which with all of the social and externalities that we know. So the biggest challenge I think we have right now with the GDPR in Europe, but potentially as a lesson learned also from others who are doing their own data protection laws or privacy laws around the world, is that so far this law has been a huge legislative success, but it's been an enforcement failure. And even though we had like initially the first big fine and the first cases being resolved relatively quickly, we're now approaching almost the 3 years of the application of this law, and we're still waiting for massive enforcement to happen from, for instance, two of the main regulators in charge of implementing it in Ireland and Luxembourg, which is where most of the tech giants are being headquartered. And if we don't have those sanctions coming up, and I'm not just talking about monetary fine, because the goal of this legislation is not to just like, throw fine left, right, and center, but if we don't have this enforcement coming and strong sanction that also ask company of here, you've collected data that you should never have in the first place, you have to remove this information, or here using a profiling technique that is actually pervasive and too invasive, you need to modify it. So really making the change of business model in a way that protects better people, then we'll stay in this sort of scenario where we are right now, where a lot of companies are expecting of like, should I invest in modifying my business model to do that? Should I make some of the changes? I'm also not really certain what change should I be making. So there is a lot of help that needs to be made in making sure everyone is compliant towards it, and basically putting a lot of the political will in making the GDPR in reality as much political will has been put in making it a legislative reality. And so we're pushing a lot for this enforcement to come, not as a punishment towards company, but as making it a reality and making it that, okay, if we spend so many years trying to move for this development, and if we see how data abuse are creating issue in our society in many aspects, even beyond the protection to the right to privacy, we really need to put the focus there. So I think you will be, what is interesting is at the moment, the biggest proponent of GDPR at the time, which include us, sometimes also become its biggest critics because of this expectation of, okay, we have the energy and we want to make it true. And I think this is where we can link it a little bit to also the reality of the right to privacy, sadly. It was mentioned by Madame Pillet that the right to privacy at UN was really consecrated in 2013 with the resolution on the right to privacy, when we had massive scandal of how it was being abused. And it's a little bit an unfortunate reality that, this consciousness and these changes around the rights in the digital era are happening only after massive violation happens, while we could have a proactive approach and have those discussions on how to create business model, but also use of data and use of privacy technique from government to private sector that from the get-go have privacy data protection and security embedded by design, and develop that. And there's a lot of innovation to do in this area. So I think there is a narrative discussion on stopping talking about barrier and block to innovation, because other innovation is also possible, but it's also putting the energy to make it happen. And that we're not yet seeing that change. But I think the discussions we're having today and hearing from many others on what everyone is doing is encouraging, because this is where we collectively need to go. This is where we all collectively agree that, we're not saying don't use data, don't develop tech, don't do those things. It's consider the externalities of what you're doing, consider what data you really need for this, and consider how innovation can really truly serve people and how you can maintain people being in control of this. And this is where you're going to go. There was a discussion about the trust, the confidence that people will have in it. And I really appreciate the comments that were made by the Conseiller d'État that you can't force the trust on people. You need to earn it and you need to demonstrate it. You can't just be like, please trust me, I've done this, use that. And I think we've all sadly learned of that through the COVID-19 crisis, when you have government developing apps very quickly and having to partner with tech giants to do them, because of the reality of if you need an app, you need to deliver it through the phone. So you have to work with Apple and Google. If not, the apps doesn't reach people. But if you don't think within your infrastructure of will people trust it? And if you just have a message of this is fine, please trust it, you know, WhatsApp is worse or whatever, this is not how you earn the trust of people. You need to rebuild the conversation, and also shows that innovation can be done differently and can be done in a way that truly integrate privacy and people's rights and give them the actual control. So the trust will come from them, but you have to demonstrate that you're trustworthy, basically. You cannot expect from us to trust all of you, and that will somehow magically happen. So I think the GDPR gave us a lot of the tools to help happen, to help having this trust happening and those changes happening, but we need to collectively put the political will to make that happen.
I will get later with Creus a bit on how can we convert that into products as well, because GDPR can also be an advantage to European companies in order to position ourselves towards the international competition, right? But we need to be very precise on how to embed GDPR into our processes, algorithm, technologies, because it's at the beginning it's not obvious. At the beginning it gets very complex before it gets easier. So the roadmap from GDPR down to the market is essential. But we will get into Creus. Creus has some ideas on that, and we'll touch later. So I would like to move to Sebastien. Sebastien is a Swiss lawyer, a prestigious Swiss lawyer, specialized in data protection, intellectual property, cybercrime law, and private policy, and business law. And he's very active. He's a lobbyist also in Switzerland. He has strong opinions about privacy, but also about the identity project, things. Then your views on that will be highly interesting in complement to what Pierre Maudet just mentioned before, right? So Sebastien, the floor is yours. You have microphones.
Thank you for your invitation. I'm really pleased to be here. So Switzerland is a little bit, as usual, a special case, you know, because we haven't the GDPR now. We have our national law that will be fast the same, but not really the same, because in Switzerland, even if you are selling a lot of data, the high amount you have to pay will be 250,000 Swiss francs. So it's peanuts, to take a word that seems to be the right one. It's peanuts when you are selling or treating illegally the data. So we have a lot of topics now about everything that has already been said. The first topic is that for Switzerland, we have to gain now a recognition of adequacy with the European Union. And Switzerland hopes to get it, but we have some doubts, because we think that European Union won't accept that in Switzerland, when you are going against the law, you have to pay so less money, and you have no other way to enforce all the companies to respect the law. In Switzerland, it will be conducted by a prosecutor. That will be a different way of thinking about what should happen when something was wrong, so that it's not administrative procedure, but it will be like this. And so we are expecting the adequacy from European Union in some months. Now they're working with UK, and they have finished with UK, and the next step will be Switzerland. So our new law will be effectively efficient in 2 years, I think, because we are late with the law. We still need a lot of text, as it was happening with GDPR. And so we hope to be able to have a new, how could I say, a new way of incenting all the people to work better with data in 2 years. 2 years is a long time, even if we are now in a COVID period. So a lot of people have said it doesn't work. So we have changed some rules, because we have conducted negotiations with European Union about Schengen data, that were the data that had to be more protected. And now we are going on, but our rhythm, legislative rhythm, is slow, because in Switzerland, the law has always to be perfect, you know. We take a lot of time for it. And so during this special period, we have no no law that is really effective. Our law is from 1992, and the iPhone doesn't exist in 1992. So you have to understand that nobody can do anything. As Data Privacy Commissioner, what I can do when I have a problem, I have a data break that has already happened for perhaps 20,000 people, 120,000 people in my region. I could only take my phone, call the guy who was responsible for the server, and I told him, if you don't correct it immediately, I will call the media to explain how your job was worse. But it's changing, and now we have this law about identity. This law is a version of a private version of identity. So a lot of people are against this law. A lot of people are for this law. The people who are for this law are supporting the law, say that the public administration is not able to develop so complex projects in Switzerland because we have had a lot of problems with older projects and in cantons and in the whole federal state. I had to stop a project that was really expensive for the patient dossier here, the files, because it was hacked at one moment. We didn't reach the security level. And we saw that perhaps private companies can do it better. That's the way we are going now. We need to vote about it. If you don't know how it works in Switzerland, we vote about on a lot of topics. Citizens are really interested in taking their future in hands, and they can say this weekend if they agree with the proposal of the Swiss government, which is this proposal is said as we don't have the means to develop it by ourselves, and so private companies can do it. But some problems are appearing because in Switzerland, if you are Google, Facebook, Microsoft, or everyone can compete to get the market. So it's not like in France that perhaps you have a bad company that isn't really trustful and they want to compete. If they win with the price and other things that are key things, they will get the market. So we cannot stop it. So we are a little bit afraid of what could happen if the company that will win, as for e-voting, a Spanish company was implicated in one project and then they go in bankruptcy. What can happen with all the data when they go in bankruptcy? So the people are divided. We are now 50-50. And the problem with that, as Monsieur le Conseil d'État Pierre Maudet has explained us, what then if they say no? So my opinion is that we have some really good schools with the Polytechnic schools here in Switzerland, in Lausanne and in Zurich. We should give them more money to develop some projects that will be semi-public and semi-private projects. And we should say them, you have the best researchers in the world. So if you need money, ask it, we'll give you money and develop the project for the identity of our citizens, because it's a question of supremacy. You know, if something happens with all these data, you can have a country that is really down in some minutes. We have already spoken about this, and I think it's strategically wrong to give it only to private companies, because I have some private companies, I have startups and so on, but I think when the problem appears, you are not able to control what happens with this company. I cannot go as Data Privacy Commissioner, even if I would. I cannot go in a data center and say, just show me. They will tell me, no, there are some secrets. We have a contract, but you cannot come here when you want and control what we are doing. So I think that is the most important problem we have now about the control. The control is only on theory. Practically, I cannot do. Even if I have a lot of problems with the database, I cannot take the police and go in one building and ask them, okay, let me see what happens now. I need evidences. It's impossible. So we need to find perhaps a go-between between private companies and public authorities when there is something independent that will come and control and say, okay, it's right or wrong what they say. we have tried to propose it to our government after the case I have already spoken about, to have experts that are independent experts, that they don't live in the country, they don't live in the region, and they come to control that everything is happening like it was previous, that all the rules are respected and the contracts and so on. And these experts could be perhaps chosen by United Nations. It could be experts from other countries. They are totally independent and they can just control that everything is okay. And I think now we need to find a solution to be practical, because you can make a lot of theories. Everything will happen when you lose some data, and then everyone is coming and saying that you have done it wrong. Yes, if you have lost, you have done wrong. But before it comes, before it arrives, I think we should have these special controls that could be directed by a supranational authority, conducted by experts that are well known by everyone, and nobody can contest the competencies. Because if we don't do it, we are always coming after the rain. And that's the problem with all these cases. You can get a penalty. You can even in Switzerland, perhaps you will receive this the police in your office. But what will change? What I want to say that we need to prevent all these problems, and we need to work harder to prevent all these problems. When we have done the job to say to the people, it was wrong, you should pay this amount. Okay, that's right. We have spoken a lot about what we are expecting from few European authorities that are in Ireland and Luxembourg. But at this moment, I was expecting it before, to say the truth. I saw that with GDPR, all the framework was good to go forward and to change a lot of things. It's slow for me, really slow. I'm working in another country than Switzerland. And I think all the companies, they have in mind now, okay, they won't come here to ask me some things about it. Even in Switzerland, we have companies that have complaints in other countries before the CNIL, in France and so on, but nothing happens now. We know that these complaints are now coming, but we don't know about the Article 3, how is the vision? Because you know, we have with GDPR an extraterritorial article that is really interesting, that push a lot of pressure on all the companies in the world. But how will this article be interpreted by the courts? I don't know it. Nobody knows it. So we have a lot of questions, no answers. And at this moment, during this period, that is a special period, all the questions are still open. We can speak about the right to portability. That's really interesting, fundamental right, but nobody knows how to make it work. I'm making my PhD on it. And that's really, for me, the moment to imagine other way to control that things are working well. It's not necessary to have always someone who is telling you that you have done it wrong. Perhaps to be more positive, we should have some support of people, and you could perhaps ask control at one moment that's important for you when you develop a software or project without no penalty. Nobody can tell you, okay, everything was wrong, you should do or make it like this. So in my opinion, now it's a multilateral way to find. There is a multilateral way to find for all the people who are really interested, who trust about data privacy, that are fundamental rights, to be able to have a control that is up our normal control. And I'm a controller, but I should say to everyone that I'm not able to control everything. I'm coming always after the rain. I should find another solutions to solve the problems, to prevent all these problems without having always the bad role, you know. I'm not the bad cop and there is a good cop. No, that's not the way. And I think the country should speak about it, should take a lot of experts, make them together, make a think tank, and then when they have solutions to propose, we should make a convention about data privacy control as fundamental rights, and perhaps we will find another way to help. Because the reason for everyone who is really interested in this topic is to find a solution to help, to solve the questions, to know how to do it well. Because when you have a company, you're just, I'm always telling, I can live with any answer. I cannot live with questions. That's really difficult. So if I have a solution that is proposed by any authority in Europe, I will take it. For me, it's easier. So I can manage my business, I can minimize the risk, and I will go straight on, and I will be happy, because this is not for my core business. My core business is perhaps to sell something or to organize something. And at this moment, you can make a lot of text. You can explain the notions, the new rights, but in fact and in reality, the people, they need a help that is practical help. We can make modelization and so on, but each business is different. And if they could have someone who is a reference without judging anything that was made, I think it could be really interesting to raise the level of privacy in the world.
I agree, Sebastien. Thank you very much. I give you a floor once again, Steve. I think, and again, WISeKey is, as you know, one of the candidate identity providers in Switzerland. And our view was that all Swiss companies that have technology that could basically be used for this project, we are far too small to get that type of responsibility. And then this is a fact of life. I mean, WISeKey, even being a NASDAQ listed company, we don't have the size and we don't have the capability to run such a complex project with full accountability. Because there are two aspects there. One is the aspect of the software itself. I mean, you need to have Swiss software, which open source needs to be, this is what we did on the e-voting project in Geneva, needs to be made available to the government so the government could take whatever decisions in the future to modify, to improve, and to add. It has to have a decentralization capability, like using blockchain. It has to have capability of analysis of data, like using AI. So all these questions were not asked. These questions, as you say, should have been an expert group. We have a COVID expert group. Why don't we have a digital identity expert group, right? On where the international expert and Swiss expert could work together. What Mr. Maudet said in his introduction, then Geneva has this knowledge. I mean, we have all the stakeholders here in Geneva. Why don't we bring them together, right? But if we are investing billions of dollars or fighting or buying the next fighter, airplane fighter, which will cover our physical protection in terms of space, we should put the same level of money to protect the digital protection of the people, right? Because it's exactly the same. We are just protecting Swiss citizens against any potential abuse in the future. So I think this is, I think it's a good thing that it has started. I think this goes a bit in line with what Steve mentioned on Privacy 3.0, and maybe Steve, I'll let you go into that because obviously from Microsoft you have a lot of experience on that. But I think we need a bigger play in Switzerland in order to mature a project like that. Steve, you want to say something?
Yeah, I know we haven't really touched on artificial intelligence itself. I know Chris will offer some thinking on that, and I'll be happy to engage in that conversation. But as we wind down this thing on privacy and the way companies behave, I think we ought to be aware that the glass is half full. It's not primarily empty. And for example, Microsoft, when GDPR was announced, we went through a massive engineering investment. It was years of work to develop what we now call our privacy dashboard. None of that was doable just because the law changed. We had to do massive amounts of work, very expensive, very difficult, lots of engineering technologies and thinking as to how this could work and be scalable for a global process. So we adopted GDPR globally on the day it came into force in Europe. So these things do matter, having these things that companies can respond to. And my other one is the UN Guiding Principles on Business and Human Rights, and Navi's role in how all of that came about. The development of the idea of human rights impact assessments has really penetrated at least into the larger tech companies. And as we think about artificial intelligence, that's one of the places where I think, fortunately, this is the glass half full. People understand they need to start thinking at the very design phase, the ideation of a new project, what this will mean for human rights. And so my main pitch is that rather than thinking we need to reinvent the entire human rights regime, we need to be better at driving through persuasion, through multi-stakeholder engagements, actual applications of all the incredible tools we have at our hands. And I'm very concerned that if we try to rewrite all this in today's world, there are those countries who will not really want to increase the human right to privacy. They'll want to increase the power of surveillance. So let's work with what we have creatively, cooperatively, and find allies to move in the right direction. But I don't want to monopolize. I know we have this other thing.
Total agreement. I think we are all seeing. So that opens a very good space for Creus to join. So just a full disclosure, Creus is the founder of Arago, a German artificial intelligence that has merged with WiseKey. So we are only one company now. WiseKey is a cybersecurity identity company. Arago is an automation AI company. And actually, the reason of that merge is to create a European player that could position itself towards an alternative to whatever else happens anywhere in the world. We need to have European innovation and position. Creus is also advisor to Chancellor Merkel in the digital transformation projects in Germany, and he's very much involved in the COVID task force. So your experience an AI expert and also advising the government will be much welcome for this forum. So Creus, I'll give you the floor, and maybe walk us through the AI, how AI could become the disruption that we need in order to, I will call backwards the technology, right? As a way of automating trust and automating privacy. How can we automate privacy and trust using AI?
So, I mean, there are multiple approaches, and let me start from the beginning with something totally non-AI, which is the problem that we today have a society where unfortunately a lot of people do not attach much value to privacy. Right. For example, in Germany, we had this discussion about COVID applications. There was a very small group, but very loud, who was extremely protective of privacy. They won. We've got a most privacy protecting application. When the application was released in the App Store, #1 download, top downloads was WhatsApp, and #2 download was the privacy protecting COVID app. And that says everything, right? The valuation of privacy is, it's not in people's minds. And if you look at the authors of the big three dystopian books of the last century, right? Like 1984, Clockwork Orange, and Brave New World. Everything, like almost everything that these authors imagined would go wrong, we have implemented. Only that the thing that they couldn't imagine that it would happen without dictatorship, right? And we didn't need dictators to implement all this to ourselves. All we got was comfort. So the exchange we made, exchanging a lot of freedom and exchanging a lot of privacy for a bit of comfort, that is something that has to go into the mind of society, because otherwise we're just having a philosophical discussion here that no one cares about them because they download the next thing that collects their data and works on it. It's great to see that a lot of companies actually hop onto the bus and say, like, no, this has gone too far. We need ethical thinking in our projects, and especially into AI. And let me explain why this is important in AI, right? It's AI is not the big super intelligence that you hear on the talk show. It's not what we have to be afraid of. It's not the thing that will determine that humans are bad for the planet and kill us all. AI is because it works on data and knowledge that comes from people, it is basically a multiplication of us. And if we give bullshit data to the AI, and if we teach it bullshit knowledge, and if we have the AI learn from people who behave contrarian to our behavior in society, then we will have very bad AI. And why is this bad? It's because AI multiplies, right? If I am a linear person, if I put my knowledge to work, I have a linear effect. I can have my time and that's it. At some point I'll die and I'll have some effect. If I give my experience to an AI and I have the AI act, that's what the big potential is, right? I can multiply my experience and it can be used thousands, millions of times per second to actually do something. This is why AI holds such big business potential, because it can automate literally everything. at not the need of standardization, but just the need of having the necessary experience. Multiplying that means going from, normally this would have taken me a month, you can take it down to a second, right? That's what's happening with AI. The problem is if this is happening at a bad level, not at a business success level and so on, if this is happening at a level where people are trying to do malicious things, where before it was very expensive to spy on everyone, now I can, having the knowledge of spycraft, I can now spy on everyone because the AI can do it. That is a multiplication of bad effort. And I think that there's two things that we need to know. A, we need guidelines of what is acceptable and what is not acceptable. B, we need to be at the forefront in the world that values privacy and other human rights of AI, so that we can tell anyone who's trying to do like the bad things on purpose to say like, don't even try because we're so far ahead of you. And I think this gets lost a lot of times in the discussions that are out there. We don't just want to be ahead in AI because it's commercially viable. We want to be ahead in AI because eventually someone is going to do something not very nice with it because it multiplies experience. Experience can be used to do good things and bad things. So if we find someone who's trying to do bad things, we need to be able to actually act against it. And I think this is one of the main efforts that needs to be made. I think it is very difficult to pre-regulate AI. So I know that there's ethics commissions, for example, in Germany that make stands of what algorithms should, like what type of test algorithms should be performed. Guys, we don't even have enough AI expert yet. So the people who could validate this are the top of the experts who could validate the other expert. That's completely unrealistic. The question is, what guidelines do we need for results, right? The results, that's what we regulate. We don't regulate how an algorithm works. Like there's no one in the administration, and the administration doesn't pay well enough to hire these people. There's no one in the administration internationally who will look out for this. It is companies that have to have a self-interest to actually get this done. And I think GDPR is a very good example. It gave companies a self-interest because of the fines, because of the ability not to sell in the market. All of a sudden, people care for this. And I think that what we underestimate in Europe is that because there is GDPR, not every company has to come up with their own compliance rules for privacy. In other countries, every company has to have their own rules for compliance and privacy, and then it has to be verified every time they create a new contract. This is a huge disadvantage for other locations. And yes, GDPR is not perfect by far, right? It sucks that we have to click in the internet, surfing the internet all the time and so on, but it's a great starting point, and we're not using it as a commercial advantage yet, and I hope that we'll be doing so. To me, privacy is one of the most important things. The question, and I've already had a bit of chat here in the Q&A with Zoe. That's why I took my camera offline, because you didn't always see my bald head, right? But can there be too much privacy? Yes, sure there can. I mean, if privacy starts to interfere with other fundamental human rights, like liberty or the right to health, and these type of things, then there has to be a consideration, and the consideration is a legal procedure. Like what gets ahead, and all these things are in place. The problem is that what is not in place is the ability to multiply this. And this is, I think, why it is really important that companies step up. Microsoft is actually a very good example. I know Steve can't say this publicly, but I'll say it for him. Is doing much better than other tech giants. Because Microsoft has approached it from an external view, basically, rather than trying to say like, okay, these are our commercial goals. How do we make privacy fit? The privacy office at Microsoft actually looks like, this is what our values are, and this is what we value. How do we make our projects and products fit? And here comes the next thing. Currently, people trust big tech companies, or generally business, more than government. I think this should be a fantastic motivation for government to step up and finally get their act together. Government is way too slow. We see in the corona crisis that decisions are made post-mortem, right? All the decisions are being made in government are after the knowledge is like everybody knows. Currently, we're discussing test strategies for COVID. Like, test strategies are friggin' out the window since we understand how mutations work. We know that there's no way you can test everybody every day and be safe, right? That just doesn't work. It's the same thing as vaccination, right? We know there are mutations. So how do we deal with this? And governments are behind. A lot of large companies are ahead of this. They have much better concepts. And this is why people trust companies more. I don't think that's a good idea, because companies tend to be not legitimate, right? Unless everybody becomes a shareholder or legitimized. I think that this should not be a reason to punish the companies who stepped up when other people didn't make a decision. It should be a way for government to actually step up and get these fundamental things, human rights, privacy as part of human rights, but also the question of what is free speech and what isn't free speech and so on, get that done with. Like, that's where it has to go. Because in a world, and to get me back to artificial intelligence, where we have artificial intelligence, it is absolute key that we have this well defined. At WiseKey, right, we have a technology where we can have end-to-end security for data. So we know where the data comes from. We know why it's trustworthy. We can make much better decisions on it because we don't need that much data to actually have sound statistics. But it has to be clear, is that actually legal, that this company acts in such a way so we can say the AI should do this or the AI shouldn't do that. Otherwise, we'll just optimize for economic profit. And I don't think that's all we want, because that could be short-term. We need to be long-term. Thank you.
Thank you very much. So I would like, we have about 50 minutes more to go. And I would like just to open the debate about the surveillance capitalism. When I joined the UN very young, I spent in the UN 20 years, working with this view that humans should own their digital identity, and their consent should belong to the person. And during this journey, I was confronted to all sorts of technologies that's supposed to solve that problem. There was the Gopher, then there was the web, then there was the X25 networks, the PDN, then there was blockchain, and now it's our AI. Tomorrow is going to be something else. But the bottom line is that 70% of the world doesn't believe anymore. I mean, you have an international force now that they believe technology companies and experts and people like us are actually part of the problem and not part of the solution, right? So how can you balance this mistrust? And it's amazing mistrust. I am a member of the WEF, and we have discussions. And when I talk to other people, they say, yeah, but the WEF is always the same people, it's the same companies, the vested interests. The solution is not there. So how can we for once develop a technology architecture that will ease that concern? That the concern of people is that they are getting into, and COVID is an acceleration of it, they are getting into a surveillance society where we're going to be controlled, where cameras are going to be filming us all the time, where our bio data is going to be collected, where our digital profile is going to be more valuable than our analog profile, whether basically we might even disappear, because humans have liability in comparison to the technology. How can we reassure the world that this is not going to happen? And maybe, are they right? Is it going to happen? So I throw the question to you guys to debate about this point. Steve, go ahead.
Yeah, well, I'm happy to kind of kick off the conversation. One of the challenges is this is not a technical problem. It's a socio-technical problem. And when people say that companies should solve it with their engineers, it's the wrong approach. The engineers can develop more efficient ways of addressing particular questions, but most of the hardest questions are about human values, human worth, and the social environment we want to create. And by the way, the social environment changes across the globe. It's a commonplace that when Americans think about privacy and Europeans think about privacy, those are different concepts at one level. So much more in Europe, in my experience, has been about human dignity and the formation and opportunity to develop a personality. That's not the way an American by default thinks about privacy, which is about somebody snooping on what I'm doing in my secrecy. And getting those things worked into a technical solution is not really the way. We have to have a much broader, deeper engagement. And that's why we're huge advocates for multilateralism. I refer to it as 21st century multilateralism, because the 20th century notion of companies develop, civil society opines on it, governments might or might not react to it. It's just not going to work for these global problems we have on the global internet. We need everybody to be defining the opportunity, defining the potential risks and challenges, and what would constitute a meaningful solution to that. And then we have to iterate constantly because new entrants will come in. So I think part of it is just raising our expectations of, we have a responsibility to engage, not just wait for either government or companies to solve these things. But I'll leave it there to see if other panelists have a perspective on that.
Sure. Thank you, Steve. Alana?
I was just going to say, Steve, you articulated that so much better than I could, and I totally agree with you. It is not just a technical problem. It's definitely a socio-political, legal problem. I like what you said earlier in terms of impact assessments. That's exactly, and Chris emphasized that too, in terms of ethical decision making. We have to bring that kind of thinking into our decision making, and we have to make it part of our DNA so that when we leave our offices and put on our other hats, we don't do exactly what Chris talked about, because he's absolutely right with regards to, in our private lives, a lot of people just disregard this because they are not thinking about the implications for themselves and for society as a whole if we keep going in the direction of not caring about it. I also really liked what Steve said in terms of multilateral, and just don't go in your little box in your own company or whatever the other hat you're wearing at that time. We really do have to work together on these big problems, because we are at a time of such rapid, unprecedented change, and talk to each other. I mean, even though, yes, in the EU, GDPR, it's very, human rights is front and center in terms of the GDPR. You go to even the most recent iteration of PIPEDA in Canada, and although it's there, it's not front and center. It's not part of the legislative rhetoric. Yet I would argue that it is more of the Canadian sentiment than when you go and look at some of the American laws, that the patchwork that works through privacy. But the core, in terms of what makes us feel uncomfortable when it gets in front of us, is there. And it's the kinds of things you were talking about, Carlos, in terms of surveillance and control. And we have to build on that. You know, what is it that makes us all feel deeply uncomfortable?
Totally. Thank you very much. Estelle, please.
Thank you. Yes, I agree with what has been said by both Steve and Alana. And maybe as a way of example, also to just illustrate how civil society still to nowadays is mostly consulted to explain part of the issue, is that what we mean also by consultation and transparency and meaningful consultation is a lot of the time solutions are being created without us knowing, and then we're presented with it and basically requested to give our seal of approval to it. This is not a meaningful consultation. This is not a way to engage there. And this also does not help with this with this image that sometimes is being given to privacy advocate of like, you just want to stop everything. It's like, you never allow us to be part of the conversation to help build products. And we actually have ideas and want to bring things to the table, but the only thing you request from us is just a nod and not even a seat at the table to be able to discuss how to do it. This is not meaningful engagement. And I think we want to be constructive. We want to put ideas out there, and we do it. But we need to have a better process to do that, if ultimately we're also going to be the users and the voice of the users to actually use those technologies. So it goes back to the whole trust conversation before. You cannot just expect that we'll just blindly give it, but if we're part of it and help understand how things are there, and also help understand better the challenges that everyone is facing in building those, it just creates a better understanding and ultimately better product also, hopefully. But we need to get to that point where the conversation from the beginning includes everyone, because it will benefit everyone in the room.
Okay, so I would like to end it's 1 hour and a half, and people sometimes complain that Zooms more than 1 hour are tiring. Despite that, we have something like 120 people still on the Zoom. So thank you very much for all the participants. Thank you for the panelists to answer questions. I saw the Q&A was pretty active as well. And thank you very much for your insights. We would like to maintain this discussion. Again, WISeKey and OISTE organizes those roundtable pretty, once every 2 months, and we bring different stakeholders. But I think the discussion today was very instructive, and it's also a discussion that gives hope. I think, as I say, we always see the glass half empty, and we need to see the glass half full, as there is a lot of technology innovation that is solving all the problem. Maybe just 1 minute each of you just to finalize, and then we'll say goodbye. I give you the floor. Chris, start.
All right, I'll maybe make the suggestion for one of the next roundtables here, because we have discussed now privacy as a single entity, and while discussing privacy, we've been discussing trust and non-trust and distributed trust and transparency. And I think that the question of trust and transparency, that's worth a discussion in itself, because it goes into the question how technology uses data. Is it trustworthy? Is it not trustworthy? Is the data available because there is huge transparency, and so on? And I think that oftentimes we think that transparency is the solution to abandon trust. And I think we could have a great discussion about how we need both trust and transparency. And that would actually drive privacy into technologies like AI.
Any other closing remark?
I'll just add one thing. We use the term human-centered a lot inside Microsoft, including we have an office of responsible AI. You can look at it out on the web with all of the engineering practices that we've adopted, but human-centered is at the bottom of that. And similarly, we have a mantra inside the company. Back when it was possible to walk the halls of the buildings, there would be posters. Microsoft runs on trust. This notion of it is end user trust that is the foundation and the future of the company. And if you're not human centered, you're really focused on technology and profit maximization, it's just not the way we think of what our opportunity is. Our opportunity is to enhance human lives, to solve global problems with technology, but it has to be focused on human centered, which is why, as a human rights advocate, I'm delighted to see these kinds of conversations happen. Thank you.
Thank you, Steve. Thank you very much. Sebastien? Mute. You're mute. You're mute, Sebastien.
I will just add something. We have a lot of hope about privacy by design or by default. This concept was invented by Anne Cavokian a lot of years ago, 2012. And now she's speaking about another concept that seems to be really interesting to me in the end of the discussion, is ethical by design. Just not only privacy. Okay, you're now compliant to the rules, but go forward. Is technology doing something good or not? And I think we should already try to find other ways to mitigate all the interests and all the risks, and to give the best solution, not only the economic solution, but the best solution for humanity, for the people. What's the best for them, not only technically, legally, economically. And in the end, I have seen that some people are speaking about this ethical by design, and it will grow up because all the people, even in the end of the life, I'm 50 now, I have 4 children. I'm not speaking for me, I'm speaking for my children. So what could I do to manage all this data so that they are not afraid of it? Nothing can happen against them when I'm not here anymore. And that's ethic point of view should be, I think, more integrated in the discussions for the lawyers and everyone, but the lawyers are always speaking about the law and the law. No, there is not only the law, but values, and these values even if they are not in the law, they should conduct our behavior.
Yeah, fully agree. Ethical by design, human-centric, human at the center of gravity, which is what Weisky has been saying. All that constituted what we are, humans, right? And we want to prevail. We want to stay here. We want to keep evolving and not be replaced. So yeah, whatever we can do on that will be amazing. Any further closing remarks, Alana, Navi, or Alana? Yeah, Alana, go ahead, please. Go ahead.
I was just going to say.
Sorry. Okay, Navi, go ahead.
Yeah, just very briefly to say, I mean, you learn so much from discussions like this, but you also then get to understand there are complexities in all of this. I think what I've taken from this is to work much more to get people to understand the link between data protection and the right to privacy. It's true what Chris says, most people, especially the young, are quite willing to give up their right to privacy for comfort. But how will they react if that data is misused, as it happened with the election scams and so on? So that would be another level of discussion. And also we should go into who censors all this? Is it governments? Should we leave it to companies like Twitter kicking out Trump as a member, and Facebook setting up a committee of experts to guide it on what it should censor? So these are all aspects affecting the right to privacy, the larger aspects of right to privacy that our youngsters who are putting up their photos on Facebook and so on don't understand. So thank you for the discussions. That's my remark on this.
Thank you, Navi, for your participation. Always a pleasure to have you. Alana, a few closing remarks.
When I was a teenager, I worked on part of the Ontario, Canada's delegation in relation to the UN Human Rights of the Child. And it was a great experience. It's a time of great hope. And you have conversations like this, and we are at a time of real flux and change. And I too am a parent, and I'm concerned in relation to what will happen with my kids. But you hear the thoughts of the fellow panelists, you hear their closing remarks, and I have to say I'm excited by every topic that's mentioned. And so there is a lot of hope, and there's a lot of excitement, just like there was when I was working on the UN Human Rights as a child when I was much younger. So thank you so much for hosting this.
Thank you very much, Alana, and the rest of the team. I always say ethical people develop ethical technology, right? So thank you very much for your commitment individually and through your corporations, and I look forward to continuing this discussion. We need to protect our kids, as Sebastien said. I mean, at least leave them a better world than the one we found, if that is possible. So thank you very much, all of you, and thank you the participants for your commitment to stay with us. Thank you for your questions, and we look forward to see you very soon. Thank you, guys. All the best.